We're missing one accused. Why was this accused brought up before I was in court? Where's my orderly? Why is this accused here? Who brought him here? Who brought you here, mister? Where's accused 5?
The application, I gather, is not being proceeded against him. Service does have some value or not. There was discussions and...
Well, that's good.
Thank you.
So they're not proceeding against 5?
Indeed, sir.
Right. So the only issue is why accused 2 was brought up before I was in court. Right. Yes.
Thank you, my lord. I first wish to extend an apology. There was miscommunication between the state and myself with regard to the convictions. I have now verified that accused number 5 was only convicted on an attempt to the dealing in drugs charge. This application is therefore brought only in respect of accused number 2, who is now cited as a defendant for the purpose of this application.
Yes.
My lord, this application is brought in terms of Section 18 of the Prevention of Organised Crime Act, 121 of 1998.
Do you have a copy of that section for me, perhaps?
I do, my lord. I beg leave to hand it up.
Thank you.
My lord,
Who's appearing for the accused?
I'm appearing.
You appearing, Mr. Trevor? Yes.
my lord, the application
18.
subsection 1.
1.
My lord, the application is premised on the fact that the defendant, who is before court, has benefited from the offences to which he was convicted in the criminal proceedings before your lordship. My lord, from the facts of the matter, we have verified that the accused was convicted in the dealing in drug matter, and
Well, you wish an opportunity to pursue the application provided for in Section 18.1, is that right?
that is correct.
Right. And you don't proceed, you don't propose moving it now.
My lord,
You propose only making it.
that's correct.
Yes. I'll hear counsel for accused 2.
As a piece of support, my lord.
Hi, please, court, my lord. We cannot object to the state launching the application
Yes.
at this stage. It would be in dispute whether there was any benefit derived.
Yes, well, in due course you'll get a chance to deal with it.
Yes.
Right, so you don't, you have nothing really to say except you note that they bring the application.
As a purpose.
Right, let me just find out how this application is going to proceed. So how do you propose proceeding with the application? I think the correct way for you to proceed, subject to what you have to say, may be by way of producing affidavits.
That is correct, my lord. For the
So then, do you propose filing a proper notice of motion with attached affidavits, to which the accused in due course will answer if he wants to and reply, and then we'll deal with it?
My lord, the arrangement that I've made with my learned friend is that we will engage in a formal discussion at my offices, and
That's a separate issue. I'm just trying to deal with the formal court process. In other words, I don't want this court to sit in limbo without some procedure by which the application carries on.
my lord, should the order be proceeded by way of an agreement with the state
Well,
of the
that's
defense?
what I'm saying. I'm not catering for that provision.
Yes.
I'm catering for a fight. So
My
now
lord, then in that regard, we will have to file affidavits.
you'll file affidavits,
Yes.
and the normal application rules in the civil application rules will apply then,
In terms of poker and in terms of
or in terms of poker. Correct.
this particular
Right. So the order that you want from me is to note that the application is made, and to postpone it sine die, and the parties will file affidavits in
That
due
is
course.
correct, my lord.
Right. Mr. Crevier, is that an appropriate order?
Yes. As a court business.
Thank you. In this matter, the state brings an application in terms of Section 18.1 of the Prevention of the Poker Act. What's the proper citation of that statute?
My lord,
Prevention of Corruption.
Prevention of Organised Crime Act.
Prevention.
121.
Just wait. Prevention. Organized crime. 1 to 1 of?
1998.
Thank you. Isn't 1998 the correctional services? Isn't 1 to 1 of 1998 the correctional services? I think it is. Are you sure? Right. In this matter, the state brings an application in terms of Section 18.1 of the Prevention of Organised Crime Act 1 to 1 of 1998. Remember, in terms of that act, whenever a defendant is convicted of an offence, the court which convicts the defendant may an application inquire into the benefits which the defendant may have derived. The state launches that application only, and in due course, as provided for in the statute, will furnish affidavits, as will accused 2 if he opposes the application. The only order which I need make is that I note that this application in terms of Section 18.1 has been brought, and that I postpone it sine die. Accordingly, make the following order. The application brought by the state in terms of Section 18.1 of the Prevention of Organised Crime Act 1 to 1 of 1998 is postponed sine die. Thank you, Mr. Javier. Right, so then the remaining accused can be brought up. Where's Mr. Duplessis?
I believe he's downstairs with his client.
Well, he's supposed to be in court. Lead. Can you see Keke anyway? Can't see. Where is he?
Sitting there on the side.
Where am I accused? Can you just one? I need these accused to come up. All of them. Accused may be seated. Mr. Mashiani, while we wait for accused 3, Mr. Du Plessis submitted to me that the position of the accused is that they are awaiting trial prisoners, notwithstanding the fact that they've been convicted, on the basis that they have not yet been sentenced. So I want to know what the position of these prisoners is, because as far as I know, they've been convicted, and I want to know whether they must be treated as convicted prisoners and have the privileges which attached, and convicted prisoners entitled only to the privileges of inmates who already have been sentenced, or whether they are awaiting trial prisoners and have free access. I looked at the statute in the short time I had available. I couldn't find the answer, except there's nothing dealing expressly with convicted prisoners.
Indeed, madam. There's only two sections or categories of people that's either sentenced or not sentenced.
Yes.
The convicted informed still falls within the categories of the awaiting trial up until the sentencing stage.
Yes.
And once they are sentenced, it's only then that they change the category. But as of now, madam, they still fall under the awaiting trial, and they are entitled to all the other privileges like any other awaiting trial, despite the conviction.
Notwithstanding the fact they've been convicted of extremely serious offences involving not only violence, but certain of them also activities in relation to drugs.
Well, unfortunately, that is the position.
And what power do I have to give instructions in relation to the prisoners, the accused? You don't know.
I don't know.
So you'll find out for me before next time. Do you know what powers I have, Mr. Du Plessis? I don't know whether the statutes...
I would submit that in terms of the Prison Act, those functions are not for this court to exercise. The Act makes it clear that the accused is entitled to be treated as far as possible as if he was on bail, subject to security considerations. Now, that is for the Department of Corrections to deal with properly. They must assess security risks, etc., etc. But it's not for this court with respect to to exercise those functions. That's why we have an inspecting judge as well, supervising the implementation of the Act itself. So in my submission, this court should not deal with those issues. It should be dealt by the authorities who are meant to exercise those powers in terms of the Act.
But those security issues, including the dissipation question, which arises now only in respect of accused number 2, are issues that fall directly within the purview of this court. So do I not need to, am I not entitled to demand of the Correctional Services Division that they apply proper controls in respect of access, cell phone activity, access generally through the internet, etc. Take accused 2. There's now going to be an application, well, there is already an application, just not been founded, to, I assume, seize some of his assets. So now it's an easy thing for him to go and start giving directions from prison as to what's to happen to his assets to avoid the effects of this. So these are things this court must think about. I mean, you can't look at the law in a vacuum. We have before us, and the same with the other accused in relation to their own safety, the safety of others, the safety of this court. So these issues fall squarely within the purview of this court on that basis.
But with respect as far as
Yes.
situation of
You say the statute's the statute.
Yes, as far as accused number 2 is concerned, surely my learned friend for the Asset Forfeiture Unit
Will bring application.
If she considers that there is a risk that his asset would be dissipated or hidden or whatever, she with respect should bring an urgent application to an appropriate court
To deal with it.
for the appropriate order.
We'll take the issue of shackling. Yeah, I'm prima facie against shackling, as you know. But once you're convicted, does that apply?
Well, with
What are the
respect-
prison regulations? What are these accused could theoretically try and run away right now?
Well, yes, indeed, my lord. But
I mean, these are things we need to think about. We haven't. Security is an issue which I must deal with,
well, with respect,
particularly in respect of myself.
Indeed so. In my submission, the court can make whatever appropriate orders relating to the conduct of the case in court.
Yes.
Now, as far as shackles are concerned, obviously, if there's a security risk, if you have the normal situation with one orderly in the court, that may be appropriate. But with all the security in place as it is, with respect,
Well, we don't know what's coming, do we?
well,
And we particularly don't know what's coming if people have the ability to communicate freely.
well, my lord,
Because then you sit and you plan things, am I right?
it may be so.
I'm not
but
saying
where,
that these
where
are-
is the line drawn?
Well,
The
that's
person cannot be kept in isolation, surely. And the authorities, and I get back to my initial point, we have the authorities here, the people from correctional services.
yes.
Surely they must be competent enough to take the necessary measures to
Well-
avoid any further.
Well, one doesn't know.
But they should, and with respect, your
What-
lordship, even with an order from your side, from your lordship's side, cannot ensure that they do their job. They must just do their work properly. That's all. But it's not for this court, with respect, to take over the functions of the department.
Mm. Are they not a department which I have the right to demand appear before me to please explain or to say what the position is? Well, they're not lawyers.
Well, indeed.
That's the answer. Yeah, okay.
Sure, the court may,
Right.
may ask them to appear.
Yes. So the position is this matter must then stand until the 17th to run until the 19th of November. The accused may take note that the likelihood of me granting any further postponement in the matter is extremely unlikely. This matter must get finished, sentence must be meted out to the accused, and life must carry on from there. I'm not likely going to tolerate any application for further postponements. So whoever wishes to have witnesses present or counsel present must make sure that such counsel and witnesses are arranged well in advance so that they come to court on time. There are 3 days set aside for this hearing. There are 6 accused. To the extent that the accused need to divide up the time of the 3 days, including the state, between them all, they must do so, because this case will finish and you will be sentenced by no later than the 19th of November, barring some catastrophe. Do all of you understand what I'm saying to you? Yes, and thereafter you will be sentenced prisoners, so then the current issues don't arise. Right. The matter is remanded until the 17th of November 2015. This court accused to remain in custody.
Lord,
Yep.
the order concerning the reports, I don't think that has been.
Oh, you want me to make an order?
As the court pleases.
What's the form of the order? The Department of Correctional Supervision is requested to produce a report in respect of accused 2, 3, 4, 5, 6.
That's it.
Mr. Kruvier, is that right?
Yes, just an order back to the court.
Yes. I add in addition to the
Thank you.
Court adjourns.
Alrighty then, thank you ladies.
Okay.